Our next two speakers are even more so. Both Julie and Marc are partners in the law firms. They do some teaching at college, but the most important thing is they're really passionate. Marc has been not just a star, but a superstar in some recent years. We've done things on social media, and I think social media is one of the most fascinating topics. Our board had a case about a year or so ago that was really intriguing in terms, including getting into the issue of private Facebook versus public Facebook, which is a whole nother lengthy topic that I think we're going to be hearing more about in the coming months. Julie said that sexual harassment is something she's been kind of working on and involved in for 30 years, and of course some people think they didn't invent sex till 10 years ago, but I think that stuff's been around for a while. It's definitely going to be a growing industry. And then I'd like to also introduce Jim Sprague, who's our Chief Administrative Law Judge. Jim has bachelor's, master's degrees, law degree, and all with high honors. He was a law clerk for a Supreme Court justice that I knew well, Craig Wright, who's since passed away. But Jim, as I would put it, and I mean this as a compliment, is somewhat like a walking Wikipedia on employment law issues. And he's a little nerdy and a little, whateverish that way, but I'd rather have it somebody that really knows all these nuances in and outs. So I think we got a great panel, and hopefully you've got a lot of questions and aren't shy, and we only gave Jennifer initially 45 minutes, but we've got 2 hours here, and if by chance I skip out before 4 o'clock, it's because my wife and I need to drive down to Charlottesville, Virginia, where our grandsons are. That's also some guys, Madison, Jefferson, and Monroe, did some good things originally in writing things for America and setting a good example on some issues. So we've got a great panel, and I'm going to turn it over to Jim, but we encourage the audience to be freewheeling, and we don't want you to be shy. And again, once we're done at 4 o'clock, feel free to buttonhole Jim or some of the others if you've got some additional questions. And thank you very much. And I'll put in my final plug. Remember the evaluation, because we read those very carefully. We want to know what to do more of, what to do less of, what we haven't touched in this program, so that next year's we can make it even better. Thank you very much.
Thank you, Chairman Casey. Hi, everybody. Jim Sprague. This is going to be, I think, a really interesting panel, and these guys have a great dynamic, I can tell you, from just the preparation that we've done. I think the game plan generally is that we're going to give each one just a small segment to present their own sort of special kind of viewpoints on things and where they maybe are hoping to go. It is a panel discussion, so it's obviously somewhat freewheeling. I may drop in from time to time with a question and just sort of to prompt things. The intent certainly isn't to go for 2 hours without any Q&A, so anytime you've got a question from the audience, please feel free to do that and ask that question. And we will have our mics, our special roving mics out there. If you wouldn't mind just waiting for just a second till the mic gets to you to ask the question. That way everybody can share in your wisdom. And with that, I think we can probably get started. So
I'm Jen. We're fast friends. I just spoke with you. I did want to mention there was a question that came up at the break. What is D&I? And I'm sorry about that. That's me in my own bubble. D&I is diversity and inclusion. And so if you are in HR, if you are an equal opportunity, I have labeled you all as diversity and inclusion professionals. It's just a philosophy about the way we discuss our work environment. And for the state of Ohio, diversity and inclusion not only focuses on people, so thinking about it more traditionally in terms of recruitment and retention, but it looks at engagement. It also looks at how we review our policies for hidden barriers. And then it goes as far as touching our products and services, so making sure that we are serving the diversity of Ohio and all of its people. So it's a philosophy kind of the way you look at it, but if you Google diversity and inclusion, you'll see that lots of corporations have these people, and it's definitely a hot thing right now. So like I mentioned at the beginning of my talk, all of our agencies are creating full-scale diversity and inclusion plans. So if anyone is interested in learning more about that, happy to talk to you. So sexual harassment, it's bad. That's what I want to talk about.
All right, so I have never sat still for 2 hours straight, so that's going to be an accomplishment if I can do that. So I just wanted to, just from the get-go, first of all, I think full disclosure, Julie and I have known each other for many, many, many years, so if we're sort of needling each other, there's a positive history to that. So
It could get really hostile.
Don't think
Yeah.
we're really that mean to each other in real life. But I guess the one thing I want to emphasize and make sure we talk about sometime in the next couple of hours are some of the very unique public sector issues that you have to deal with regarding sexual harassment. You know, one of the things that we have heard a lot about with regard to the Me Too movement is some of this stuff could have and should have come out earlier, not just because people weren't reporting it, but because people were signing non-disclosure agreements. You don't have that in the public sector. You have the public records law, so you have a lot of issues sort of on the other end of the spectrum in dealing with some confidentiality questions and concerns that people might have. So I want to make sure we talk a little bit about some of the specific nuances with regard to investigations you have to deal with in the public sector, and also that you, as I said, some of those public record and other issues that you might have to you will have to be concerned with as you do investigations.
I'm Julie Davis. I'm more of a private sector gal. And I think as we talk, you should be thinking about me or people like me as the people that your employees may be calling. You know, the outside lawyer who may or may not be referring them over to someone who knows more about the public sector. But I represent a lot of people who are accused of sexual harassment. I represent some people who are accusing other people of sexual harassment. I represent private employers who are trying to figure out how to do the right thing, get it right, improve their training, avoid being in the newspapers, avoid being slammed on Twitter. But today, I think you should think about, do I really want a situation where someone picks up the phone and thinks it's a good idea to call Julie Davis? I've been doing a lot of speaking on Me Too, and one of the reasons is 30-some years ago when I started practicing in the labor and employment area, I was developing companies' very first policies. I was doing some of their very first trainings. And guess what I heard from a lot of men in particular, but some women too, I'll never hug anybody ever again. And boy, am I never going to go on a trip with women or put myself in an office alone with women. And it took a good, 5 or 10 years to get everybody to calm down. Now, calm down. This is not a black and white situation. That doesn't make a lot of sense, what you're saying about, no touching ever, no hugging, no lunches, no trips. And it's really seen for a good 10 or 15 years that for many, many good workplaces, things had calmed down. And people kind of understood the real black and white areas, and then we were just working around the edges on, what baby pictures or not might be a problem for some people that some of us think are maybe too sensitive, that kind of thing. Well, we're back there because, in part, of the Me Too movement. But maybe we're back there because of something else. The study that Jennifer referred to, and I thought her presentation in 45 minutes was excellent about this area. 50% of women in that study said that they have been subjected to sexual touching. Physical sexual advances, 50%. Now, some of that may have happened a long time ago, and the Me Too movement is about some things that happened a long time ago. But 50%, when you're dealing with the Harvey Weinsteins and these elite, supermen who have gotten away with things for many years, that's part of what the Me Too movement is about, right? Well, there are more than 60 women who have come forward about him. So we clearly have some really egregious stuff going on still. And we're not talking about the baby pictures here. We're talking about, and it may be unfair to the men because certainly there are some men who are the recipients of harassment by other men or by women. But mainly the Me Too movement is a lot of women who are coming out and saying, look, this has gone on, it is still going on, and it is not edge stuff. It's still some really basic, gross, vulgar stuff. Some of it involves touching. I spent time last year on a project working with groups in Philadelphia on a pilot program to try to train restaurants in the small to medium sector on how to help avoid sexual assault. We're not even fooling around with harassment and verbal stuff or anything. We're just trying to minimize sexual assault in Philadelphia restaurants. This is 2018, and we're still dealing with that. So I did want to kind of refocus that while Jennifer and all of you will be called upon to do really tough stuff, which is to make judgment calls on this edge stuff of is it offensive or not, did it create a gender-based, unwelcome, sexual maybe, that is tough stuff, and it involves judgment and good atmosphere and good culture and good decision-making. But there's still a lot, the Me Too movement is telling us, of the old-fashioned stuff that is still going on that women think they shouldn't have to deal with, and we should make sure that we are doing our utmost to address that. That's what the Me Too movement is saying. And I actually wouldn't mind starting but asking the audience, what do we've actually distilled what we think the Me Too movement is saying, and it's not just one thing. As you've heard from a lot of pundits, I think it's a number of different messages. What do you think the Me Too movement is saying? Come on. It's Friday afternoon. We're all going to get busy here. What do you think the Me Too movement means? Come on.
Mumblings. I hear murmurs.
She's been a victim. How many women in here think that they have been the subject of sexual harassment?
And how many men in here are surprised to see that many hands go up? I mean, that's...
How many men think that they've been sexually harassed? Do we have very many in here? How many women have reported the sexual harassment? Not very many. Retaliation is something I'm going to spend a chunk of my time talking about. How do you create an environment that is truly an anti-retaliatory environment? Because I believe that's where a lot of stuff has to start. If you're going to change, you got to change how people feel about retaliation. So we're going to talk about that. We're also going to talk about social media. We thought it would be fun to do it in the context of talking about Me Too and sexual harassment. But boy, does social media come out front and center in terms of how it's coming to people's attention, as well as how you deal with it in investigations and how you deal with it in the workplace. So we'll be talking about that as well. Anybody else? Anybody else like?
Julie, I'm going to turn that back
Yeah.
on you if I could, because you guys, in a way, are the experts, and I know that. Just to kind of warm people up a little bit, what do you think are the primary messages of Me Too?
Nobody else wants to jump in? Clearly, it's a lot of women saying, we're tired of this. We're in solidarity. I've heard it described as we've been siloed off. We feel like we've been siloed off, and now we realize we can speak out about it and say something. So a lot of women across the country, across the world, who are now speaking up. And there's been a lot of speaking up and speaking out in the past year or so for a lot of different reasons, and this is going along with that movement. What do you guys think? What else?
Well, I mean, so first of all, is there a question?
A comment. I think it's saying it's time to stop worrying about being a victim or feeling guilty that you might have somehow been responsible for what happened. Just get over that, and speak up and stop.
That's good.
Yeah, it's about giving a voice, right? So, I don't think you ever, get over it, but I think what you're saying is it's giving people a voice and they feel like they can say something in more of a protected space. And I think that's important.
It's safety in numbers.
Yes.
Well, and I think the other thing it says to me, and I have a couple of thoughts on this. One of the things it says to me, not as much as what it's about, because again, I'm not going to disagree with what Julie or you said, because I think you're right, what it's about. But what it says to employers is that you better be paying attention to it, and you better be taking it seriously. I think part of the problem is, and I'm not necessarily saying, well, I don't want to qualify this. I think part of the problem is employers, generally speaking, check the boxes, but what kind of message are you sending as an employer to your employees about what your tolerance or intolerance level will be when it comes to this? And I think what happened is people have gotten comfortable in a bad way. But the other question I have is, what is this going to mean 6 months or a year or 2 years from now? Because one of my concerns is that some other people will be sitting up here 10 years from now, although I'm not that old, I could still be here. Some other people will be sitting up here 10 years from now saying, what do you think about this Me Too movement that just started in 2028? Because we ignore it and go in the opposite direction again. And, you know, in so many things, I don't want to make this too broad, but in my view, a lot of things, even outside of the employment realm, the pendulum's here, then it goes here, and sometimes it does and sometimes it doesn't settle in the middle. One of the things that comes to mind, and this is a little bit beyond the question, so I'm sorry if I
Keep going.
go on, but
Keep going.
is something that Julie said. You know, one of the things that we saw in, there was an article in the Columbus Dispatch a couple months ago talking to mid-level managers at various companies. It seemed relatively random, or, you know, who the reporter knew or whatever, about what these men thought, and what part the message that they got from the Me Too movement is, as Julie said, I am not going to be in a car alone with a woman, a coworker. I am not going on a business trip with a coworker who's the opposite sex. I am not going to a lunch or dinner by myself. That's discrimination. That's sex discrimination. That cannot be the message for what the Me Too movement means, I hope, because if it is, then again, all you're doing is helping the lawyers who are either going to sue you or defend you for what would be more traditional over-the-plate sex discrimination as opposed to sexual harassment. So, I mean, that's one of the things that really comes to my mind here and really, frankly, bothers me about some reactions that I've seen in the media and, you know, that you hear people talking about.
There's a question.
My question involves when you have the allegation, now that it's been in the big, it goes on social media. We've seen how it's happened in Hollywood and elsewhere. But when we have a state agency or a county agency, how do we handle the situation, since we don't have the process of being able to fire somebody the next day instantaneously? We have to actually prove that the allegations are substantiated and we have some due process, unless it's obvious with the grievances that there is a safety violation and there were more evidence. But we have to be like lawyers and make sure that we're following and giving due process. So how does that impact us with having to deal with the Me Too movement, social media, and the claims that everything's going to be, everybody wants a decision immediately now, and that's not how government works.
Well, that's not how the legal system really works either in this too, right? There's you know, there's a court of public opinion and then there's the legal processes, right? And so, you know, for you as an agency, I mean, I don't want to minimize it, but it's really doing the thing that you should always be doing. The problem is with government in particular, I love government, I have my whole career, but we are very reactive and we are not proactive. And so being proactive in talking about what are our policies, what's our plan, what do we need to do, what do we need to tell our employees up front? Because you're right, we can't just turn around and, you know, fire somebody if, you know, we don't have the evidence or the case hasn't built, right? And it could cause more problems. Even moving their desk may be a problem, right? And so it's about being able to try to strategize that before it happens. And then in it, making sure that you are following those policies and working with your HR, working with your in-house legal, or working with whoever is advising you on those things. Because that's the other thing. Like for that individual that is accused, they have rights too, right? And so, you know, there may be things that you can do, like separate them. In some cases, if you have mediation programs. But the important thing is to try to think about it proactively if you can. And right now, I mean, to be fair, the only reason why we have started at the state of Ohio, you know, individual sexual harassment training that wasn't in EEO is because of Me Too. You know, and so we're trying to be more proactive and preventative in it. Having our agencies look at policies, thinking about how does social media come into play. We've seen a lot of cases start on social media, and then they come into the work environment, and we're finding our policies are deficient right now and how to handle some of that.
You know,
So,
Okay.
I'm sorry. So I was going to say maybe this is a good time to sort of dive into a couple of the specific public sector issues relating to the investigation on a big picture. And I'm only spent a couple of minutes on that. Before I get to it, though, in preparing for this, you mentioned social media. So here's a couple of currently or soon to be released apps that relate to this issue. First of all, something called Blind, which is an anonymous workplace community with insights from your peers. Second of all is Glassdoor, which is a searchable database of anonymous employee reviews. I assume they mean employee reviews of the employer. All Voices, which will allow employees to anonymously report instances of harassment, discrimination, and bias in the workplace. There's something I was just reading on a New York Times article this afternoon about the Me Too movement called Vault, which will help, it's interesting because they say women, but anybody, help people save evidence of alleged sexual or unlawful harassment. And Callisto, which is already out there, it's used for reporting sexual assaults on campus, and it's being modified so it could be used for the workplace too. So social media will become more of an issue in terms of what you have to deal with over and above just the Facebook post or something like that. And one of the questions might become down the road, is an employer obligated or smart to monitor those things? Having said all that, and again, we can talk about that some more, I do want to talk about investigation stuff real quick. And this is a little bit in your outline, a very brief outline that I put together, because you're absolutely correct. The public sector is so different than the private sector. In the private sector, fair or not, some, again, I'm going to say men because it's usually men, are getting fired before they get any investigation whatsoever because that company is making usually a business decision, wise or otherwise, certainly not necessarily fair to the alleged harasser, that you're gone. We're done with you. You're gone. We're not going to wait around for another week even. In the public sector, I represent a lot of cities and counties where things don't move as quickly. I can't imagine how much faster cities and counties are than the state. And you have due process requirements, and you have collective bargaining agreements that you have to follow. So some of the things that you should be, thinking about in advance, or not necessarily thinking about them in advance in detail, but so some of the questions you have is, so who's going to be responsible for doing this investigation? It's nice to say we're going to get an outsider to do the investigation, but that's really expensive, time-consuming, and in some ways, not for good reasons, you lose control of that. So I think that's the exception. What kind of documentation are we generally going to want to look at in preparation for diving into the facts? It's something else to think about. And these are public and private sector concerns. Who are we going to talk to? Who are the witnesses? Where are the documents stored that we need to collect during this investigation? But now let me get specific to the public sector. In the public sector in Ohio, again, subject to what might be in your collective bargaining agreement, you have the absolute authority to require employees, including the alleged harasser and the alleged victim, to answer questions during an investigation. However, many of you have heard about what's known as Garrity warnings. And what Garrity is a U.S. Supreme Court case, it's summarized very briefly in your outline, that says that as a government employer, you're subject to the Constitution. Private employers don't have to worry about this stuff. So you cannot compel, the government under the Fifth Amendment to the Constitution cannot compel somebody to incriminate themselves. So if you want to call somebody in and force them to answer questions under penalty of insubordination, which usually results in termination if they refuse, for a refusal to answer, then what you need to do is give them what's known as Garrity warnings. And Garrity warnings basically say, in a nutshell, you have no right to remain silent. You have to answer all questions completely and truthfully. Anything you say can be used against you in a subsequent disciplinary proceeding. Nothing you say can be used against you in a subsequent criminal proceeding. If you are going to that step, you need to be talking to your legal counsel to make sure in the more egregious sexual harassment cases where there is touching that you're not screwing up a potential criminal prosecution. And I'll leave it at that. There are some criminal, I don't want to get in the weeds on this, but there are certainly some criminal defense lawyers who think even if you give them Garrity, there's going to be problems. But, again, we're not going to go there. The other thing you have to keep in mind, and this is just noted over on page 3 of your outline, is what's called Piper warnings. And there's an Ohio Supreme Court case called In Re Piper involving the city of Dayton, where long story short, the rule as it stands today, because it's changed from legislatively from what the case initially said, is that if I am the focus of the investigation, not just a witness, but the subject of the investigation, that before you question me, you have to tell me, preferably in writing, that I have the right to be represented by an attorney during that questioning. This is aside from my union rights, which I'll mention here in a sec. So again, in the public sector, that's another delay in the process. Piper and the statute that it applies don't give us any guidance about whether or not that's a 24-hour notice or whether my lawyer's in Tahiti. So I'll be ready to talk to you in 3 weeks. The truth is it's something in between those time frame-wise. But that is another hoop you have to jump through. Let me back up and say one thing about Garrity, too, so there's no misunderstanding. Absent a requirement in your collective bargaining agreement, you do not have to give Garrity warnings. You can bring somebody in and ask them questions, and as long as they're answering, that's great. It's only at the time that you need to compel somebody to answer because they're refusing. And if somebody's refusing to answer in that context, make sure you ask them why, because they basically have to say, I'm asserting my right against self-incrimination. But again, all of these things are hoops you have to jump through in the public sector in order to actually conduct an investigation. And then in a union setting, and again, this is true in the private sector or the public sector, employees have what's known as their Weingarten rights, or the Ohio cases in Ray Davenport that SERB decided several years ago that basically says that whenever an employer wants to question an employee in a manner that that the employee reasonably believes could lead to discipline, that employee can assert his or her rights to have a union rep present. Again, many collective bargaining agreements might simply say you got to let the employee, as the employer, you have to let the employee know that they have that right up front. All right, I zipped through that. That is a very superficial
got a question on the other side of the room there.
So,
Well, I still want to answer her question, so can we do
Yeah.
that? Yeah.
I'm just here.
No. Before we get to the other question, to clean up on yours, this I think is true in the private sector or the public sector, which is if the accusation of sexual harassment or the accusation comes across on social media, you treat it as if it came in your door. And now, what it looks like and how you proceed from there could be different, but you don't ignore it. It may be that you can't do anything with it. It may be that you can't identify who's actually accusing who. But don't ignore it, because it becomes part of the body of evidence that will indicate what do you know or don't know about what's happening in your workplace. And believe me, social media can get into the area of rumors or gossip, and sometimes you pay some attention to that. Me Too is telling us pay more attention to rumors and gossip and things, and do what you can reasonably do to understand if there's evidence there or a thread you should be pulling to understand if you've got a problem with your workplace environment. But some social media accusations are extremely clear. They've just decided to go out in public like once upon a time you used to have to corral a reporter and get someone to write a story, right, to go public, as opposed to coming in your door with the complaint. Here, anybody can tweet it or throw it out there on Facebook or in a variety of ways. What I'm hearing from many people is they often are not getting it directly from the tweeter or the person who's posting it on Facebook, but they're getting it several layers removed. I've seen something, maybe on one of those apps now that Marc was talking about. I just saw something and it really bothers me. They're an upstander. It really bothers me that that is happening in my workplace and I saw it, and I'm going to be the upstander and say something, but I saw it and it was reposted 3 times on Facebook. So then you've got to be the detective just to try to figure out what you can figure out about the accusation. But from that point, treat it like a real accusation, see what you can find out, start your investigation, and
See where it goes.
It may develop into a full-blown investigation. It may not. But don't think that because it happened on social media or because it happened publicly that you should ignore it. You should do what you can. Sometimes it might seem silly because of the nature of what was out there, but when you calmly and reasonably let everybody know that you're going to be treating all of this very seriously and you're going to be looking at it, they'll understand that you're being super sensitive to try to make sure we don't have a harassment issue here. We actually had this as an example we were going to talk about because one of the first things that happens, okay, you've seen the tweet or the person came in the door to say something about the third over Facebook post. Do you immediately have to go to the person who's accused to make sure that he doesn't start ripping into this person on Facebook, on Twitter? And I'm going to throw that out to our panel before we get to the next question, just like, do you have the right to tell Mr. being accused, please don't conduct this fight out on the public platform. I want to do a good investigation. Please stay off of Twitter or Facebook. We'll deal with this internally now that it's out there. Of course, you may not beat him to the punch, right? And he may counterpunch on Twitter or Facebook or some platform, and then you've got that to deal with. But I know in the private sector we can certainly pull him in and say, look, we're telling you as a rule, don't do this. We're going to deal with you fairly and reasonably, but we do not want a Twitter war over this. So here, it's come in the door. We're dealing with it, but please, keep this a private investigation. We don't want it public. Can you do that in the public sector?
Let's get a quick response from the other 2 panelists, and then I don't want our question to sit too long. Yeah. So let's get that.
I was just just a follow-up on what she was saying about calling them in. What kind of, when the panelists are responding as well, what kind of ramifications would you have about telling an employee of let's handle this internally, because they have the right to an attorney and they have a right to, be able to go public with a lot of this information unless you have it in some policies or procedures about once it's been reported, could you have that in place to kind of keep it in-house and have it go through an internal investigation and have ramifications if they try to make it go on the public stage?
So I think it depends on how the person who is making the accusation, how formal they want to take it, kind of. So for us, if we were to get that, we as the agency wouldn't file a formal complaint for an employee. Does that make sense? Like, they would have to file it and take it formal. We, though, would keep it internal because we would find a problem with it and want to try to deal with it. And so we may initiate an internal investigation on behalf of the employee and go through our internal process. Now, we at the state of Ohio do have an internal process in code. So it's our process. And employees can avail themselves of it. We can kind of put them in it. We kind of work with HR on it. And the outcome of that is more of a policy type of review situation where we're ensuring policy is followed. Now, could we pull the person in who's being accused? We can talk to them, but they do have a right to have representation. They have a right. These are things that are also in our statute. In our rule as well. And we can't prohibit speech. Obviously, we can't stop them from talking. But this person would, I assume, be a manager, and most likely, if it's, or maybe not, it could be a coworker too. Trying to inform them of what our process is. And as the individual that is accused, they, as I said, they do have rights too as an employee. But we, as the employer, at least for the state of Ohio, we wouldn't turn around just because we saw something on social media and file a formal case. Like, we wouldn't do that. So they would have to be up to that individual who may then call Julie, and they may decide to file, and then we would work with the Attorney General's office to defend it.
Yeah, so I think you absolutely can call that employee and tell him, again, usually him, that, look, this has come to our attention. You're not questioning him. You're just telling him, we are going to look into this, and let's not blow it out of proportion. So we are telling you, you need to be very careful. You can't tell him he can't talk about it outside of work, depending on what he's talking about. But you need to be very careful about